Welcome to the second session of the workshop Knowledge and Legal Standards of Proof. Now we have the presentation of Carlotta Pavese. She's an associate professor of philosophy at Cornell University, where she specializes, among other topics, in epistemology, action theory, philosophy of mind, and philosophy of language. She is also editor of Philosophical Review and Ergo, and an associate editor of Analysis Review. Today she will be presenting her work, Knowledge and Culpability. So, Carlotta.
All right, thank you very much. So when I was invited, I was like, oh, why did they ask me? It's not as if I know anything about legal epistemology, nor I've written anything about legal epistemology. And then I thought, well, I really want to go to Girona. And I really like the prosciutto here, the Serrano. So I thought, well, I better come up with something. And so I did write extensively on knowledge and action. And I did think that, there is nearby topics here in the relation between practical normativity and knowledge that are really relevant to the law and that can benefit from learning from the law. And so that's what my talking is about today. It's not really about statistical evidence or standard of proof, but rather about a relation between notions such as the notion of culpability and knowledge. Okay. So there is a very long tradition that establishes a constitutive connection between knowledge and practical normativity. It's a tradition that goes back to Aristotle. So Aristotle was very clear in thinking that a particular set of actions that he called voluntary actions are actions that one does knowingly. So in the Nicomachean Ethics, it says, what is done through ignorance is always non-voluntary, and a man acts voluntarily when he does what he does in ignorance of what he ought to do. But it's not for to do it voluntarily if he doesn't know the particulars of which the action consists. Further, there are some actions done in ignorance that are voluntary, but the action itself is involuntary, since no one is ignorant of all the circumstances, but only of the particulars of the action. For example, these are the things that one is supposed to know for the action to be voluntary, knowing who he is, the agent is, what he's doing, what he's acting upon, or sometimes also what he's doing it with, for what purpose, in what manner, and whether in general he's doing it right or not. So according to Aristotle, voluntary actions are actions that are done with a lot of knowledge, plenty of knowledge of particulars. So the verb here used is edenai, which is not the same as episteme, but it's actually the word in ancient Greek that would translate knowledge of particular facts. So episteme really is the word that corresponds to knowledge of general explanations, general facts, but the word that would best translate the use of epistemologists, today's epistemology now, is actually edene in ancient Greek, because when we talk about do I know where I park my car, do I know that I have hands, do I know that who I am, and so on. So those are actually would be translated most likely with edene rather than episteme, because it's the knowledge of particular. So the word no here is really the word no. So voluntary action is not quite the same as intentional action as today action theorists are thinking of intentional action. So for Aristotle, voluntary action is a kind of subset of intentional action that involves especially non-coerced intentional actions, but not necessarily deliberate actions. So a voluntary action may be done by an impulse toward an action. So it doesn't have to be deliberate, but it's typically intentional, though coerced intentional action wouldn't count as voluntary. And Aristotle was less worried that today's contemporary action theories on the distinction between intentional and accidental. I was more worried with the distinction willing and reluctant. Right? So it tracks willingness more than intention, action, proper. But they are related. I think that it's not. It's kind of accurate to think of voluntary action as non-coerced intention action. Now, so for him, then, voluntary action is action done knowingly, and there's plenty of knowledge that goes with the voluntary action. As he says, it's knowledge of who the agent is, what he's doing, for what he's doing it, and also whether one is doing the right thing or not when doing it. So it's very knowledgeable action. Now, Aristotle also thought that only actions that are voluntary, in this sense, are actions that can be assessed as just or unjust. Right? So this is just and unjust. Really are just kind of subjective normative property of action, in the sense that an action is just if only if it's right. So in some objective sense, it conforms with the law in some sense, in a moral law or conventional law. It's just, in addition, if it's right and there's some state of the agent satisfied some subjective conditions, or is motivating in the right way, is the right mental state, and so on. So it really corresponds a bit to the notion that, like in action theory, often people talk about moral worth, right? As a sort of subjective property that an action satisfies if, in addition to being right, it also produced by agent in the right state of mind, the right motivation, and so on. So just like moral worth is praiseworthy action, similarly the kind of counterpart, the negative counterpart, is culpable action, and that's also a property of an action, a subjective property of an action, in the sense that the action has to be wrong for it to be culpable, but in addition, the agent has to satisfy certain subjective conditions for it to count as culpable. Okay, so now, because Aristotle thought that voluntary actions are knowledgeable, and only voluntary action can be just and unjust, then he was kind of committed to the claim that so just and unjust action had to be knowledgeable. So they have to come with knowledge. And he thought that the knowledge wasn't just knowledge of what he's doing, what one is doing, one acting, but also whether one is doing it correctly, right thing or not. Right? So it involves also kind of moral knowledge in action. Right? So this view can be cashed out in different ways. There are kind of weak version of the view, and there are kind of more strong version of the view, and also there's a view that concerns just moral worth. There's a view that is based on knowledge concerning culpability. I distinguishes them. Like I mostly will just talk about culpability here, but I think the main consideration that I make today can extend a bit to moral worth too, and I'm sympathetic to knowledge-based views on moral worth as well. On the weak view, an action is morally worth, provided it is right, just in case the action is done knowingly. And then there's also usually a kind of further condition that have to do with the motivational, the intention of the agent to perform it. On the strong view, instead, the action is morally worth, if it's right, provided that it's done knowingly, and also knowing that it's the right action, the right moral action to perform. And similarly for culpability, you can have the weak version and the strong version. The weak version just says that the action has to be knowable, so not done knowingly, where the strong version says it has to be done knowingly, also knowing that you're doing the wrong thing. Right? I only want to focus on culpability, as I said. I also really only believe the weak version of the culpability claim. Although even that version, I don't think it's quite right as stated, and kind of the plan today is to take inspiration from the notion of culpability that you find is in some of the criminal law, to overcome some of the standard problems that the weak knowledge-based culpability has. And so to provisionally reach a better version of the view. I'm not completely settled on my view here, so I hope that will be discussion that will have me in that respect. But I will give you where I am so far. All right, so both the weak and the strong version kind of have face two kind of big problems. The first is not really a problem; it's more like there's often a lot of unclarity about kind of knowledge that has to be involved here that is relevant for culpability. And here I'm going to argue that the relevant knowledge has to be practical knowledge in the Anscombe sense of practical knowledge. So it's a kind of propositional knowledge that has a particular functional role. And then the second problem that both the weak and strong version of the culpability view is the obvious one, which is, well, obviously ignorance does not exculpate always, right? So both the weak and strong version of the view seem to commit to the idea that when it doesn't have knowledge, then the action is not culpable. But it seems clearly wrong, right? The weak view says, if you don't have factual knowledge of what you're doing, then you're exculpated. But clearly, that's not true always. The strong view says that if you don't have moral knowledge of what you're doing, whether what you're doing is right or wrong, that will exculpate you. But that clearly is not the case. I didn't know is not a good excuse. Always doesn't get you off the hook most of the time. And so the question is try to understand when it does exculpate, when it doesn't. Sometimes ignorance does exculpate. If a child playing with a fire might not be culpable of setting the house on fire, since he didn't know that his behavior was conducive to, and that was the likely consequence of his doing so. But in a variety of cases, ignorance clearly does not exculpate. If I don't recycle, and I don't recycle because I don't know that the non-recycling has bad consequences, I'm still culpable, as an adult. And obviously, moral ignorance does not exculpate. So if I have all sorts of screwed up moral beliefs about things, that doesn't make me any less culpable for my crimes. The most relevant example, the Nazi, they will be convinced that what they were doing was correct, but the fact that they did it makes them culpable. So that the lack of knowledge doesn't get them off the hook. Now, a superficial look at the law actually pushes in conflicting directions on this question of whether the ignorance is exculpate or not. So there is a long-standing Latin dictum that says, ignorantia juris not excusa, which seems to sanction the idea that ignorance of the law, at least, does not exculpate, at least in the main of the law. And so that suggests, it's in defense of the idea that the strong view or knowledge-based view of culpability cannot be right. On the other hand, there is at least some indication in other areas that something like the weak-based view of culpability or the strong-based view of culpability goes in that direction, or it captures something important about culpability. So one example is McNaughton test for insanity. So this is a test that was actually originated in 1843 in England. So there was a case against Daniel McNaughton. This guy shot and killed the secretary in the Prime Minister, Edward Drummond. And it wasn't the impression that he was the Prime Minister himself. So during his arrest, he claimed he needed to murder the Prime Minister because the Tories were conspiring against him. So he had he was suffering from paranoia and wished to murder him. At the trial, the counsel put forward defense for insanity, offering expert testimony and other evidence in support of this. Following instruction from the judge, the jury's verdict was not guilty by reason of insanity. But there wasn't really a test for mental insanity at that point. The people converged on it. So after the public outrage following the verdict, a stricter test for criminal insanity was devised, and the test says that all defendants are presumed to be sane unless they can prove that at the time of committing the criminal act, the defendant's state of mind caused them to not know what they were doing when they committed the said act, and that they knew, or they knew what they were doing, but didn't know they was wrong. Right? So another example, if somebody thinks that they're acting as God told them, and they think they're doing the right thing. And so, this text kind of implicitly assumes that there's something right about both the weak. It's not just dedicating a weak knowledge-based version of culpability, but also the kind of stronger version that it's a position on insanity that one can come to know. On a culpability that one knows what they're doing and they know they're doing that. So there's a kind of, from the law you can get pushed in different directions as to whether the knowledge-based view is correct. Alright, so I won't try to defend a strong based knowledge view, the moral ignorance view. There's a paper by Gideon Rosen who argues for something in that direction. He talks about moral ignorance as culpating in many cases, in particular in cases where the ignorance is culpable. I don't know if you read the paper. It's a big, I think it's a very good paper, but some examples are really cringe-worthy because cases where, I think it's maybe the only philosophy paper where Truman is defended. Even Truman was not acting culpably. So I'm not sure I want to go there today. So I mostly won't talk about moral ignorance. All right. So then let's take the weak-based moral knowledge view and the sort of, so in that view, the sort of ignorance that can exculpate, if you take that view of its value, is a factual ignorance, knowledge of what you're doing. So whether or not you think of it as morally right or wrong. And in this respect, I want to look at the US Model Penal Code. I'm really focusing only on the US law today. In part it's because I have US students and I try to convince them that I'm right. But also because there are other criminal codes where the connection between knowledge and culpability is explicitly stated, but this is perhaps the most clear on the matter, and it does distinguish between real culpability in a very clear way, in a way that helps my case. So that's why I'm focusing on the U.S. Model Penal Code. Okay, so in the U.S. Model Penal Code, culpability is given in degree, and in particular there are 4 different kinds of culpability that are stated. So the minimum requirement culpability is stated in your hand on page 3. A person is said to be not guilty of an offense unless he acted purposely, knowingly, recklessly, or negligently, as the law may require, with respect to each material element of the offense. So the kind of culpability, then there is 4 ones. Purposely, knowingly, recklessly, and negligently. These kind of categories only apply to what they call voluntary act. So the voluntary act, so the actions that are susceptible to this kind of taxonomy are not intentional action necessarily, but they are voluntary actions. And the voluntary actions are defined as follow. The following are non-voluntary actions within the meaning of this section. Reflexes and convulsions are not voluntary actions. Bodily movements during consciousness or sleep are not voluntary action. Conduct during hypnosis and resulting from hypnotic suggestion are not, with respect voluntary actions. And the bodily movements that otherwise is not a product of the effort, the determination of the actor, are either conscious or habitual, are not voluntary. It's maybe like a conscious action that for which one has a will, then one has the will to perform it mostly fall under this voluntary action category. So only these kind of acts are the sort of things that can be done culpably, and only this kind of acts can qualify as satisfying either of those four conditions in culpability. Okay. All right, so I give you for page 4 and 5. I give you the kind of official statement of each of the clauses. So there are a few points I want to make. So first of all is that these really are degrees of culpability in the sense that each culpable state is less serious than the previous one. A defendant is more culpable when he commits the same act purposely rather than knowingly. It's more culpable when they act knowingly rather than recklessly, and there's more culpability when they act negligently than they act negligently. So it's really is degreed. And there is a kind of relation of impairment between the first and the second, and the third and fourth. So purposely entails knowingly, and recklessly entails negligently, but not vice versa. This is I'll return to that in a second. So these are all sufficient conditions for culpability. So as it is stated, at the beginning of the definition, it says he's not guilty unless he's acted purposely and so on and so forth. So it means that if he's guilty, so if he acted purposely, knowingly, recklessly, and negligently, then it is guilty, so it's sufficient, but barring extenuating circumstances. So, for example, if one is coerced into acting in a certain way, the action will be done knowingly, but that wouldn't necessarily stop. So there are few circumstances that matter here. Now the third point is that knowledge, the word know only explicitly occurs in the second kind of culpability, right? So the act is done knowingly or with knowledge, right? But there's a very, instead of knowledge, you can find pretty much everywhere awareness. So there's aware of the law, and you may wonder whether that's really knowledge. Of course, who doesn't always wonder about that? But I do think it's knowledge. It's a faculty mental state, and if you think that knowledge is the most general faculty mental state, that would be entailed by being aware. So aware is kind of knowledge, I'm sure there will be a question about that. But just pure fashion, the wording is really kind of suggested that we're talking about knowledge or awareness, and I think there is awareness is a kind of knowledge stuff. All right. Now, how do we understand knowledge So when did I start? Sorry, I'm a bit...
20. You have 20 minutes.
20 minutes, okay. So what point is what kind of knowledge is involved in the second clause? And I think that here, it really has to be the sort of knowledge that Anscombe had in mind when she talked about practical knowledge. So practical knowledge for Anscombe is a knowledge, is a kind of positional knowledge. So it's not that you're doing something while you're doing it. So it's as a propositional concept. However, as a distinctive kind of functional state, a bit mysteriously, she put it by saying practical knowledge is the cause of what he understands, right? And that might sound mysterious. What does it mean? But yeah, you can kind of see the point by considering kind of a bit of a counterfactual scenario. Take this example here, Oracle. So Bernie is told by a evil doctor that he'll be given a drug that will make him first sleep for a week, and then when awaken again, will make him feel very antagonistic feelings toward Oliver, his co-worker. Feelings that will progressively grow into great resentment until he's made to want to take steps to kill Oliver. So Bernie is told they will not be able to resist this urge, and so as a result, he'll end up committing a crime. As the sleep effects of the drug wear off, Bernie starts having negative thoughts about Oliver. At the same time, he remembers the evil's doctor plan, and so comes to know that, to realize what is happening to him. So comes to know that he'll soon be taking steps toward killing Oliver. There's little he can do to resist the urge. At the end of the week, Bernie succumbs to it and kills Oliver. While he does so, Bernie is fully aware that he's doing it, and as he did it knowingly, since he never forgot what the evil doctor told him. He had no reason to doubt that he was misleading. The knowledge of what is not practical, because it's not because of the action, doesn't play this functional role. Practical knowledge does play. This also, what we think, is a case where we wouldn't think that Bernie is fully culpable for doing things knowingly, although in a sense he does act by having knowledge, while having knowledge concomitantly with the action. So this is an example that suggests that, look, it's not just doing something with the knowledge that you're doing it that matters. The knowledge has to be in its causal. Anscombe wouldn't talk about efficient cause. For her, it's a formal cause. But as a explanatory role vis-a-vis action, that's the really key element to the practical knowledge. All right. So the knowledge that makes one culpable to be practical. It's not sufficient just knowing that you're doing it if that doesn't play a role vis-a-vis the action, like explanatory role vis-a-vis the action. Okay, so what about culpability 1? Culpability 1 doesn't mention knowledge. However, the consensus among the jurists that interpreted Muller penal code is that purposive action entails knowledgeable action, knowingly action. So that when one acts purposely, then one also acts knowingly, although the opposite will not be the case. And so, in a sense, so culpability 1 is actually a particular kind of culpability. It's may not even be the most frequent case of culpability. In a way, the second type of culpability is much more mundane. So to tell it apart, consider the first example of culpability. So, having been bullied throughout his childhood from the other children in the village where he was born, John was always had a grudge against the people living there. It's kind of autobiographical, by the way, although I didn't interview for a CEO position. Having reached adult age, he finally sees a way forward to take revenge. The local industry is looking for the CEO who will have the power to implement measures to improve the productivity that have, however, environmental destructive consequences. In particular, we pollute the nearby river, making the water from undrinkable to poisonous. With the goal of harming his previous bullies, he interviews the CEO and gets a job. Right? So this is an example of culpability 1, where the main intention is to commit something that you know even to be a crime. So that's the primary goal. of the action, and so that is also done knowingly. On the other hand, in every case where the CEO foresees the effect, the harming the environmental harm, and deliberates toward taking steps that will have that consequence, even though the primary intention of the CEO is not harming the environment. So this is a bit like in the node effect kind of scenario where the CEO is taking measures to improve revenues by improving productivity. This involves a new program. It will help us increase profits, but also harm the environment. So she deliberates about it and reaches the conclusion that she prefers making profits as much as possible, even if the cost is harming the environment. So it's a case where she does things knowingly, she harmed the environment, fully knowing that she's doing it, but that's not her primary aim. So the primary aim is to increase profits rather than. And so that's one way to tell apart. So the second case is not a case of putting it as a purposive action, but all right. So this is the distinction between 1 and 2. So if you think of it the way, then it's not as, although knowingly only occurs in the second condition, it's actually also important for the first condition, because purposive action entails non-reversible action. All right, so this is culpability 1, culpability 2. The second 2 degrees are recklessness and negligence. So here, the culpability of recklessness is worse off because typically the agent has some inch that there is a risk that the action taken will have harmful consequences, whereas negligence doesn't have to be like that. So typically recklessness also involve negligence, but many cases of negligence are not cases where the subject has clear evidence that there is a risk about the undertaking certain action that will actually result in harmful consequences. So, for example, just to tell them apart, consider a doctor who administers a procedure to a premature baby having respiratory problems. The procedure has serious side effects, end up damaging the baby's eyesight. A result that could have been averted by a slightly modified procedure. This the doctor would have known, had he kept abreast of the current medical knowledge by reading the letter issue that they don't know. So this is negligence. He should have known, but we imagine in this case it didn't have particular evidence that there was another procedure that wasn't told. He should have learned from the latest journal, but he just didn't. The reckless case, instead, is a case in which the procedure does have a serious side effect, and the doctor does have the result of a test that positively correlate with the possibility of a side effect. So in this case, the doctor has some evidence that the side effect could actually occur in that particular case. However, impatient for healing the patient and going to ski on the Alps, the doctor doesn't inquire further and goes again have a procedure. Right. So neither recklessness or negligence invokes knowledge, as if they're close, invokes knowledge. But the explanation of negligence does invoke awareness. And we are told that negligence is a case where the agent should have been aware of the consequences. And so, arguably, given that recklessness entails negligence, even cases of recklessness are cases where one should have been aware. Although the passage that I showed you of the U.S. Model Penal Code doesn't mention a fifth case of culpability, there is actually a fifth case of culpability, which is the case of willful ignorance. So this taxonomy so far doesn't cover all possible culpable states. It further allows the defendant who is not actually aware of a given fact can be treated as if he knew. If it can be established that he is willfully ignorant. So willful ignorance is actually worse than both recklessness and negligence. So it's defined as a case in which the subject is aware of the probable existence of a clear fact, but does not determine whether it exists or doesn't exist. So this definition actually, when I encountered this definition, I was like, so what's the real difference between willful ignorance and recklessness? In both cases, there is awareness of the risk, the probable existence of a material fact, of a crime or a felony. The usual example of willful ignorance, is a case where your childhood friend appears one day by saying that he wants to give you a gift for all time's sake. It's carried filled with boxes of electronics and gives you a new computer. You suspect they may not come by it, honestly. Still, you cannot buy this computer in stores yet. You really want it. So your friends have to tell you a complete story about where it came from. You say, I don't want to know. So it's a case where you kind of ignore, you really avoid learning about the fact. So you happily accept, thinking that because you do not is solent, you will have a defense when authorities investigate. So this is a clear case of willful ignorance. Now, it's interesting because when I first encountered the definition of willful ignorance in the Modern Penal Code, I actually wasn't clear to me there would be clear difference between willful ignorance and recklessness. So recently, there's been a statement by the Supreme Court that tries to give a more clear definition of willful ignorance, and the basic legal account is at page 8. So it says that to be willful ignorant of an incorporated proposition, one must have sufficient serious suspicions of it, and deliberately, as opposed to negligently or recklessly, fail to take responsible available steps to learn with greater certainty whether P is actually true. So here it seems that deliberation about not to know is crucial, or deliberation about failing to take the steps toward knowing are crucial. Again, I think here, is a place where philosophy can help a little bit, because it's not. You can have cases of recklessness where you actually deliberate not to take steps toward. So, for example, you have it at page 9. Remember the reckless doctor that we have at the beginning. Suppose the doctor, before the operation, considers whether making more tests to avoid the possibility of a side effect, and decides instead to go ahead with the procedure in order to go on his skiing vacation. So here the doctor explicitly deliberated to be ignorant, but it's not clear that this would be a case of willful ignorance. So it would probably be treated as knowing if charged. How much time do I have left?
5 minutes.
5 minutes. Good. I'm doing well. So what the legal account seems to miss out on is that what's really crucial, it seems, to willful ignorance as opposed to recklessness is that the decision is taken with the intention not to know. So that's the primary intention, that you really, it's not as if you intend to go on vacation and so you neglect doing certain further inquiry. Is that you, the goal of deliberation is that you really want to, is that you don't want to know. You avoid taking further steps in the inquiry because you suspect that they will go in a certain direction and you don't want to take that direction. And so it's typically done in order to avoid prosecution and culpability, but because our reckless doctor does not take the decision with the intention not to know or not to avoid prosecution, then it wouldn't count as willful ignorance. So deliberation may occur, recklessness case and negligence case too, but what's really important is what's the goal of failing to know? What's the goal of taking steps to avoid to know? And so there is a question whether it's enough to intend to know, or you have to intend not to know, or maybe you have to intend not to know in order to avoid prosecution. There are cases where it seems that perhaps we don't want to know. And so we are willful ignorance, even if our main goal wasn't to avoid persecution. So this is a case, you may think, well, the Nazis definitely were willful ignorance because they wanted to avoid persecution. But actually, this case is you have here page 9. So Karl Hank, who eventually was prosecuted and found guilty in the Nuremberg process, here he reports his experience at the concentration camps, where he was advised not to inspect under any circumstances. He didn't inquire him, I didn't inquire Himmler, I didn't inquire Hitler, I didn't speak to personal friends, I didn't investigate. I didn't want to know what was happening there. During those few seconds, while Hank was warming me, the whole responsibility had become a reality again. From the moment on, I was inescapably contaminated morally from the fear of discovering something which might made me turn from my course. I closed my eyes. This deliberate blindness awaits whatever good I may have done, and so on. So here it seems that clearly this is a case of willful ignorance. It wasn't done primarily to avoid persecution, though. It was more for avoiding knowledge, to avoid moral contamination more than avoiding persecution. But from this it does that even willful ignorance, as a kind of culpability, is a case that is a category of culpability that does kind of constitutively involve appeal to knowledge, because there are cases where the ignorance, the lack of knowledge, is intended. All right, so this foray in the U.S. Moral Code, and try to understand these categories, these different kinds of culpability, had this kind of function for the purpose of defending a kind of a weak knowledge base view of culpability. So one issue is what kind of knowledge is involved in culpable action, if any, and I suggested kind of knowledge has to have the functional or practical knowledge in actual sense. Anything less than that wouldn't deliver proper culpable action. The second point I made is that although not every kind of culpability constitutively require knowledge, we see that the main purposive action, knowledgeable action, are the ones that gives the primary forms of culpability, the ones that, culpability 1, culpability 2 are the ones that go with crimes like murder, right, that can be charged only if that kind of culpability can be established. Nonetheless, there are different degrees of culpability that don't constitutively involve knowledge. So the initial statement of the weak knowledge-based view is not quite correct. There's a couple of actions. But once you distinguish between degree of culpability, then there's room to say, well, the stronger degree of culpability does go with knowledge. Moreover, even the level of culpability that are less, less serious, like recklessness and negligence, they involve a constitutive connection with knowledge, because they are cases in which the agent doesn't know but should have known, either because he could have known it very easily, in the case of willful ignorance, as an example. Or I could have known, perhaps not that easily, but he was expected to know for the sort of role, social role that they were playing. They were knowns such that they were expected to know. So even those kind of culpability seem to kind of require people to consider knowledge. So by thereby vindicated this kind of strong connection to knowledge culpability. Thank you.
Thank you, Carlotta. We are starting the debate with the same model of hands and fingers. Okay.
Different sort of question.
Okay, Juan.
Oh, thank you. Yeah. Two small comments. I don't think either of them go to the heart of what you were saying. But the first one is you said that the U.S. code, all these different levels of culpability, they are stated as sufficient conditions, but it reads like necessary conditions. It says not guilty unless one of these things happen.
Yeah, did I say sufficient? No. So, if one knows, barring certain circumstances, and if the action is voluntary, then it's culpable. So yes.
The reading suggests otherwise, right? It suggests if you are guilty, then either you know or you're purposely doing it or whatever. It's just either you're not guilty or one of these things happens. So it suggests if you are guilty, then one of these things happens. So it's necessary condition.
Yeah. So I guess yeah, sorry. If I said sufficient, that was wrong. So I mean,
okay.
The initial view is you can see it's supposed to be necessary.
Necessary.
Yeah.
Okay.
So it's just in case one knows, but then there are other conditions that you have to satisfy. You have to have a certain kind of motivational state. Yeah. Sorry.
Yeah. So the more interesting point is, I think all of this. So there's a different kind of connection with knowledge that covers all of the different degrees,
yes.
Which is that the person doesn't know that harm wouldn't ensue. So it's a lack of knowledge.
Yes, I see.
That covers all the cases. So it's a different way of.
Or doesn't know the harm.
Yeah. So suppose that doesn't know that. Suppose that we're trying to figure out whether they are guilty of causing some harm.
Yes.
Right. So all of this are covered by saying that the person didn't know that harm wouldn't be a result of.
Right, but that would be too weak in certain cases.
It will cover all of them. So
yeah.
it's a knowledge-centered account of
right.
purposefully doing it, knowing that you do it, recklessly and
yeah.
willfully ignorant.
Oh, I see. But so you're saying that it's a way of thinking of moral ignorance, building in moral ignorance. Is that
No, all of these different sorts of ignorance. So if you don't know, so suppose you're accused of fine.
Yes.
So if you don't know that your action wouldn't result in fine,
yeah.
If you purposely do it, then you didn't know that it wouldn't result. If you knowingly did it, then you, of course, you did know that it would result. If you recklessly did it,
yes.
then you didn't know that it wouldn't result. And if you were willfully ignorant, then
but that's fine. I mean, like that's a so I think you're right. That's this core feature that all these four kind of capability have.
Yeah.
But you wouldn't get what is distinctive about, for example, the second type of culpability.
No.
Yeah.
Right.
So and that the connection is stronger. It's not just that you don't know.
Yeah, but you were looking for a knowledge-based account of all four, I thought.
Okay. No, I mean, so the idea was like, look, of course, if you start from a strong knowledge-based account, or like even the weak knowledge-based account that says knowledge is common to all kind of culpability, the standard objection is, well, of course, that's false. There's all sorts of way in which, and I think looking at U.S. model penal code helps with that because it says, well, there are different degrees of culpability, and the more important ones, the one that comes with the worst convictions, are the ones that go with knowledge.
Right.
And so, you may be right that there's something even weaker that's common to all of them. But for the purpose of this, kind of at least providing defense of these.
Yeah, but it's interesting. If you do think that these are central to culpability, you think, well, really, what's doing the work is lack of knowledge. knowing the opposite is one particularly strong way of not lacking knowledge.
Right. Yeah.
And all the other ones.
Yeah.
But,
Yeah, no, I think that's right. Yeah, it's a common minimum core to all of these. And so, if you really think that you should have a unified account of culpability, perhaps that's one way to go. I do think that it's worth, emphasize the importance of doing things knowingly for an interest in notional culpability. Mm-hmm. So that's why.
Thank you, Edgar.
Thank you. All this legal talk of, for instance, willful ignorance
yes.
or awareness,
yes.
knowledge
yes.
required for different
yes.
categories, I think leads us to the question that, or to the notion that it may be reasonable to state that there are epistemic duties
yes.
of people or of individuals. And I was wondering if you think that you need an account or some sort of, or is it just a presupposition, or do you need an account of epistemic duties, because there's a lot of discussion about their
absolutely.
existence or their reasonableness or whatever, to develop a knowledge account of these categories in the law. And the other question is, do you think that even if the law didn't enforce these epistemic duties by stating these categories, do you think those epistemic duties or obligations, if it is reasonable to state that they exist, should remain even if there were no legal consequences?
Yeah, so definitely. So I think that culpability in moral talk is even more fine-grained than this for. It's interesting to look at the U.S. Moral Code because it gives us at least a taxonomy degree culpability, and it gives us the tool to say, well, if you have different kind of culpability, you can still have a knowledge account for the strongest case. So, but you're right that when it comes to the moral domain, I think that there's even more fine-grained distinction that I don't think the law would make, and so that that work I definitely haven't done here. In terms of epistemic duty, it's crucial to understand in what sense the reckless and the negligence should have known, right? And why is it that we expect them to know? What are the norms in place such that they were expected to know? And I haven't given a systematic theory of that at all. Right? It really is the big theoretical task here, I think, to just give a more fleshed out account about what norms are such that are in place, such that you're expected to know. So, for example, in many cases we could know certain things, but we are not expected to know. Like if I walk around in the woods, I don't realize that I'm trespassing a private property. I could have known, by looking ahead the map of, of the territory. But usually we're not expected to know. I mean, usually those are. I mean, it's rare that you are charged with trespassing those cases, right? So, the project there when it comes to recklessness and negligence is you try to understand what's the force of that. Should know in circumstances. I mean, it seems to me that by and large here it's assumed like a can, ought imply can is a kind of assumed here. So it's assumed that you should know only if you could have known. But other than that, I haven't given account about what other norms are in place, because in many cases we could have known, perhaps not, but we are not expected to know, and so it seems that in those cases. The role that your epistemic position, your profession, the role you're playing with respect to the action in the profession, like the doctor is expected to be updated on the recent issues in his field, and the philosopher is expected to be knowledgeable of the relevant literature and so on. So those are kind of norms, like epistemic norm that supervene on having certain professional roles. But I don't think that's the only kind of. I'm supposed to be a good recycler. I'm expected to be a good recycler, even if it doesn't depend on me having any professions to be part of being a good citizen. So yeah, it has a.
Yes, no, can I add a little question? Just that sometimes the law seems to make a judgment not on or not regarding what you could have known, but what an average, for instance, an average person should have known, for instance. So sometimes the decision is guided by a kind of general judgment regarding an expectation that you might have regarding the average person.
Right. Yeah, adult person in a certain social environment. Yes. Yeah. Okay.
Thank you, Professor.
Yeah, so this is maybe slightly related, I mean, just a small point, about the intention to avoid knowing. I mean, there are, in the kind of classic cases of willful ignorance, it's a very specific intention to avoid knowing, to make sure that you don't know the P or whatever. But, somebody could also have a much more general intention to avoid knowing, in situations where they kind of feel that, knowing too much can get you into trouble, and so they just, as it were, adopt habits of, kind of not being curious about things, and maybe, not simply not keeping up with the journals or the newspapers,
right.
but keeping us also ignorant that if you were to have a look at the journal, you wouldn't even understand what it was saying. So, and I just wonder whether there's anything much to say about, as it were, these different levels about, in relation to something like willful ignorance. I mean, because in some cases, if you just, as it were, look at it locally, it will seem like a case, simply of maybe negligence or something, but when you look as we take a wider perspective, you'll see that there is some kind of underlying intention to avoid as much knowledge as possible.
Yeah, those are interesting cases. It really depends, like, on the case. I mean, so if you have a clear, like, I'm tempted to say that a lot of these cases didn't, like, it wasn't a kind of deliberate a kind of conclusion that they got to. So they may be lazy, they have a bad habit, and so those are not really deliberation. So, if you actually look at the definition, that if it requires deliberation, then there has to be a process of, like, deciding to that conclusion. And so to the extent to which those don't involve that kind of process, or even though they may have some sort of intention to know, because that's not the result of a deliberation of a certain sort, then it wouldn't count as willful ignorance. It wouldn't be as culpable as a case of willful ignorance, and they wouldn't count them as. So willful ignorance, literally here are cases where you are taken as culpable as if you knew, right? And I wouldn't want to say that those are as culpable as if you knew the relevant.
Yeah. Could I just
yes.
one little cover on
yes.
that, which is not
yes.
so closely related to what I'm
yes.
saying. There are going to be slightly difficult cases where there's a huge range of facts, any of which you could know, but knowing all of them
right.
is not feasible.
Right.
And so if somebody is treated as knowing each of them,
right.
Because they could easily have found out.
Yes.
But they won't be treated as knowing the conjunction, because they couldn't easily have found out the conjunction. And so you'll end up treating somebody as knowing all the conjuncts but not knowing the conjunction, which is kind of, and if you think about how those feed into their evidence, I mean, as far as their evidence goes, what's probable on the evidence doesn't really matter. It doesn't depend on whether you explicitly form all the conjuncts into a conjunction.
Yeah.
So that there's a danger of inconsistency in a test.
Right.
Like that.
Yeah, that's an interesting case. I mean, like, I was trying to kind of capture the intuition about culpability, and we still, even if the kind of count has to be fixed. So like in general, unless you kind of deliberated to not to know, usually for the purpose of avoiding conviction or avoiding prosecution or avoiding moral burden and so on, then I wouldn't want to count them as willful ignorant. But you're right, there are those issues that are
Andre.
Thank you, and please turn my finger into
Okay, don't worry. It's your turn. Anyway.
I think I had almost exactly the same question. Are there any, or can there be any objective criteria for distinguishing between willful, deliberate ignorance and reckless ignorance? Because in the example of Speer, we have his confession that it was deliberate. And in the example of a guy who gets a new laptop as a present, even if that guy's, even if the report of that situation says that the guy who received the present said, "I do not want to know where you got that computer."
Yes.
It may mean I do not want to know because the story is too boring, or I do not want to know because I suspect something.
No, I'm not. I was.
How do we expose you?
So in the example I given, I meant it as a case where the person doesn't want to know precisely to avoid. And I thought that in the context it was kind of clear that I was intended. But you asked a different question, which is can we prove that?
Yeah. Are there any objective criteria? It occurred to me that maybe we can apply a test of whether the suspect is going to benefit from not knowing.
Yeah.
But in this computer case, we can say again that, for example, that was me who got the present. When I heard that, when I saw that my friend is going to give me this fine laptop, I got so happy about that. This made me reckless. I didn't think of where it might come from. So I guess it becomes too hard to pin me down and.
Interestingly, it's not the deliberation aspect is not something that I introduced as a kind of naive philosopher that doesn't think about how to prosecute people. It's actually the Supreme Court that actually imposed that requirement. So it's something that they reasonably expect to be able to ascertain in some way. That depends on the case. There is an issue there about how you establish that there was a liberation, definitely. And I'm less. I was after an account of what makes it willful ignorance more than an account about how do we prove that there is willful ignorance. It's very important, perhaps even more connected to the topic of this conference. How do you establish that? But yeah. Thanks.
Federico Arena.
Thank you. I have two questions. The first one is to ask you, what do you think, if there is any difference between moral worth and moral culpability regarding knowledge? Because at the beginning you offer two definitions, weak and strong, and very reflection.
Yes.
And the question is, do you think that knowledge has the same role in moral worth and in moral culpability? Because there are some examples. There is a very well-known example from Joseph Mott with this experiment regarding intuitions on a very similar case, the one you offer here.
Josh Knob, you mean? Yes.
This head of the CEO that goes to the owner of the company says, I have a very good plan, we're going to win a lot of money, but we're going to damage, or we're going to benefit the environment. And people actually, when it's about damaging the environment, these people deserve punishment, and the probability is very high. And when it's about beneficial program for the environment, they don't deserve more. And so
Yes.
And the second one is about to understand the link between intentional and voluntary actions,
Yes.
and then with knowledge and culpability, because as far as I understand intentional action,
Yes.
in cases of willful ignorance,
Yes.
you cannot say that people intentionally did what
Yes.
they didn't know, because
Yes.
to intentionally carry a bag full of drug, I have to know that
Yes,
there is
exactly.
drug inside
Yes.
the bag. So if there is no intentional action there,
Yes.
or at least this is not the description under which the action is intentional,
Yes, exactly.
how can we say that it is a voluntary action, given
Yes.
the definition of voluntary action,
Oh.
and then there is a
Yes.
set of intentional action, and then how can we
Yes.
say that it's
Good. So the definition of voluntary action, maybe I was a bit unclear because I started with Aristotle, and for him, voluntary action is a kind of intentional action. In the U.S. Model Code, actually, voluntary actions does not entail intentional action. So it's only the action is intentional if it's voluntary, and in addition, the first two conditions apply, the is done purposively or knowingly. So in those two cases, you can talk about intentional action. And so in the case of willful ignorance, you're definitely right. It's not, if intentional action requires knowledge, as I believe, then literally the willful ignorant is not acting intentionally when they bring the money across the border or something like that. But they are treated as if they did, though, because they are treated as if they knew. Right? And so that's why they are charged with a worse off kind of culpability. So that's what I want to say about that. So you're definitely right, it's not intentional on a plausible view. Well, I think plausible view of intentional action. But it would be nonetheless culpable for how it's understood, because they understood the cases where they act as if, so they are culpable as if they knew, right? And so they're culpable as if the action was intentional. That covers the second question. The first question is about moral worth and culpability. Yes, so it's definitely true the noble effects are interesting. So noble effects, they really are about judgment about intentional actions. That too differs, right? So both cases are cases where the CEO foresees a certain consequence, bad and in the bad case, they judge that it's intentional. In the good case, they judge that they judge less that it's intentional, and it's already tricky, right? Because that challenges it's very hard to explain on actually in any theory of intentional action why that would be, because in both cases there's knowledge of what's happening, of the consequences. In both cases, the effect is not a primary intention, so it's a kind of side effect. But nonetheless, we have this strong intuition that there is a symmetry here. So yeah, that's a very interesting case. So the kind of cases that I was focusing on when I gave the theory of moral worth were cases where the consequence is the primary intention. So, you have the intention to perform that action. So for that kind of view, I don't think the noble effect is a problem at all. So in those kind of cases, the CEO plans an action, harming the environment or benefiting the environment, and does so knowingly. So in both cases, I would say that there's no difference there. But you're right that when you look at the side effect kind of cases, there is a question. Some people think that those are not true cases of intentional action, right? They're not. So that's one response for maybe. There's a lot of error theory that are invoked to explain no case that really we should like for example my colleague Sean Nichols thinks that we really should praise and blame equally. It's just that the negative balance of an act kind of somehow makes us blame more than the positive value of that makes us praise. But that's an interesting stuff about the psychology of praise rather than how we should respond to this effect, right? And so I haven't defended moral worth, knowledge-based views yet, nor culpability, knowledge-based view. Here I was focusing on culpability just because it's something that the law explicitly talks about, and so you can learn from the theorization that has been offered in the law. Whereas moral worth is less, the law doesn't give credit quite as much as it should. So, it's also, I think, an interesting territory here to explore the parallels. The strong knowledge-based view of moral worth has actually been defended by Paulina Sliva. And so she thinks that you need to know what you're doing and know that you're doing the right thing. Know that you're doing it for the action to be morally worth. There are some problems there that arise. One problem that people cite a lot is Huckleberry Finn. So it's an example of somebody that is under the impression that slavery is totally fine, and they became very good friends to a slave, and then they kind of release him, thinking they are doing something terrible, and they expect to go to hell as a result, and so on. So many people want to say that case is a case of moral worth. Releasing, freeing the slave, is something that the Uncle Ferry Bean should be praiseworthy for. Even though it was not at all aware that it was doing the right thing. So they fall under the moral ignorance kind of cases which are a bit tricky, Sometimes I feel like, well, perhaps that's just a case in which the subject was very fragmented. I kind of knew that it was doing the right thing the moment when they released it, but just all the theoretical belief were kind of going in the opposite direction. So if we think of the subject as very divided in a way, perhaps we can account for some of the intuitions there. But I'm not entirely. I think that's one of the main challenges to the strong knowledge-based. Does that address your question? Thanks.
Thank you. Livia Moscatelli.
Hello. I have a genuine question. Actually, for me, it's not so clear the difference between the willful ignorance and also the happiness. And can you give us an example of, I don't know, maybe talking about the magic example that you use for talk about the negligence and also the recklessness? Because I have the impression that maybe when you use the criminal conduct that is the crime of proposing receive property with knowledge that is stolen.
Yes.
Here the point is we aren't talking about degrees of culpability, but we are talking actually, so we aren't talking about assigning responsibility or leaving culpability.
Yes.
But we are talking maybe the system for the system, the importance is create a crime that will punish a specific action. That it's not, the point is not about the discussion about the degrees of culpability, but okay, we have a pragmatic problem that we want to stop the conduct that is buy things without the knowing that maybe is a product of crime. And I think that this is not a good, maybe a good example to explain the willful ignorance, talking about the levels of culpability. So I would know What do you think?
Yeah, so
about-
yes, I sympathize that the current statements definition of willful ignorance really kind of collapse the distinction between recklessness and willful. So yeah, there I'm with you. So that's why I was trying to elaborate on the formal statements that have been given. I mean, the general, I think. It's generally thought that willful ignorance does entail, there's always some recklessness in the willful ignorance, although recklessness does not entail willful ignorance. So it's a worse off kind of culpability. So the kind of example I had in mind were cases where, so I kind of suggested that the difference is not about deliberation, because you can also deliberate to avoid taking further steps in learning about something for the purpose of being lazy, or just to do something else instead. You just don't want to focus on the question. You want to finish things quickly. So in that case, you are reckless. But I wouldn't want to say that's willful ignorant, because it doesn't seem as if you should be treated as if you knew in that case, in terms of being charged with a certain crime. It seems that it would be too harsh to say that because you decide to not to inquire further on a question, like, and you decide to finish things, you inquire very soon. It seems that that would be sufficient for you to count as culpable as if you knew. And so the suggestion was like the primary aim of the deliberation in the case of willful ignorance is you come to the conclusion to avoid further inquiry because you intend not to know, because knowing would expose you to prosecution or to moral burden in a way that you prefer not to. So that is how I was understanding the distinction. Is that helpful? Whereas in the record, yeah.
Another example, and not this, but about willful ignorance.
Yes.
A good other example than this that is here.
Which one is it?
About in the left, then page 8.
Yes,
example of that.
Of willful ignorance.
Yeah.
So I gave a case of the Nazi at the end, the very end. So that's a case where you have a strong suspicion there's something terrible happening, but you deliberately omit asking any questions that would take you to know what's happening. And there, it seems that the intention is that you really want to avoid knowing because you want to avoid the moral burden. It's not so much that you are lazy or you want to spend your time some other way. Yeah. So I thought that was a good example. I wouldn't say that it's a recklessness. But it would be a clear case of willful ignorance.
Okay, we have 7 words, and we have only half an hour, so I ask you to be concrete, please. Diego Papayanis.
Thank you, Carlotta. I have a question about your concept of negligence and recklessness. I'm thinking in these kind of cases in which, for example, a surgeon that has some experience performing a difficult surgery,
yes,
but at the moment of performing the surgery has some doubts whether he remembers exactly how it's done, maybe it's been a long time, I don't want to admit it in public because people will doubt about my ability.
Yes.
And then he performs the surgery and everything goes fine. He does it as the best expert even though he doesn't know whether he was capable. Is this surgeon reckless or the negligent in a sense driver who does not pay attention to any instructions, any signs in the road, but never violates any objective rule of driving.
Yes.
He just drives perfectly well by chance.
Yes.
Is this negligent in your view or not? How do these cases? In your examples, there looks like you need also deviation.
Yes.
The doctor does not perform the best or does not serve the patient in his best interest. He departs from what would be correct, but in my examples, he does not depart objectively.
Yes. Yeah, so that's good. So I think you're right that the ordinary concept of recklessness tracks those cases, and those cases would count as reckless too. Here in the U.S. Motor Code, the assumption is that the action has to be wrong, and so then the question is when it's culpable, when recklessness is one case where it's culpable. So recklessness would be necessary condition, but of course the action has to be wrong for actually count as culpable in this sense. Yeah. So in my definition, I wasn't suggesting that recklessness has to be always result in the wrongness of the action. It can be that in some cases it doesn't, but if it is wrong, then what makes it culpable is that it's reckless. So I definitely agree with you that negligence can happen even without wrongdoing or objective wrongdoing. We get lucky in that cases. Yeah.
Thank you, Marianela Delgado.
I have just a follow-up regarding this degrees of the
Yes.
willing ignorance.
Yes.
And I have a question and then another one
Yes.
linked to that. If I understand correctly, so for me it was confusing when you answer about the degrees, because the way you describe willing ignorance is linked to the aim of avoid culpability. So in a way, I may have reasons to believe something wrong is happening. Something is happening, so I prefer not to know anything, not to have more information about what is happening,
Yes.
so I stay ignorant.
Yes.
But the lazy one does not have that kind of reasons. I'm a lazy person. I don't want to know anything
Right.
about the world, so I do not have like an ultimate purpose, an aim or something.
Right.
I think in the first scenario, the one you're talking about, willing ignorance, it's easy to make the distinction between recklessness
Yes.
and willing ignorance.
Yes.
But it's not in the second one, because you said like, okay, yes, it could be the case that willing ignorance could be in certain kinds of degrees.
Yes.
But that's confusing for me, because I think it's clear that willing ignorance depends on you having an aim. You have
Yes.
the aim of avoid culpability.
Yes.
So you have reasons
Yeah.
to believe.
Yeah, so I'm not sure that the aim is avoiding culpability. I mean, I was giving this Hanke example as an example where I think there is willful ignorance, but the primary aim is not avoiding culpability. It's more like, you intend not to know, because the truth will be too appalling, and you don't want to the moral burden. So it's not. So I actually gave the example of the Karl Hank just to illustrate that sometimes. I mean, I think he should be charged with willful ignorance. That is willful ignorance, but the goal is not. Presumably, at least from the way he describes his experience, he wasn't trying to avoid prosecution. In fact, he eventually confessed, and it was very, he wasn't. He was very willing, the confession that he gave, and so in that case, I wouldn't think that it's the aim is always to avoid prosecution. But I think you're right. In many cases, it is, right, and the aim is not to know in order to avoid unpleasantly more burden and I think that's absolutely true. Now the confusion between willful ignorance and recklessness. I mean, I think willful ignorance are meant to be are considered cases of recklessness, but just that. I mean, I was trying to find cases where there is recklessness, but there is no willful ignorance. Just like the relation between recklessness and negligence, right? So recklessness are always cases of negligence too. It's just that there are cases of negligence that don't count as reckless. So there's a kind of entailment relation. So similarly, I think that the way the jurists think about the relation between willful ignorance and recklessness is as this kind of entailment. And so the example I gave, or the reckless doctor, seems is a case of recklessness without willful ignorance. So that how I understood the dialectic.
So the answer was interesting for me because of something else.
Yes.
It's like course, degrees of culpability has
Yes.
to do with how serious we decide an action is.
Yes.
So it's more serious than, and so we go.
Yes.
So for me, it was like, okay, if you have an aim, your aim is to avoid culpability, then willfulness, ignorance should be in the third floor.
Yes, exactly.
Not behind
Yes.
recklessness.
Yes.
But then if you say that maybe willful ignorance is generally is recklessness, where do we put willful ignorance?
So just like so in this, so you know, the taxonomy also. So the purpose kind of culpability comes before knowingly culpability, and so. But nonetheless, whenever you do something purposely, you also do it knowingly. So there is an element there, right? And nonetheless, when it's purposely, it's more culpable than when it's just knowingly, right? So you have to understand this clause is just saying purposely, only knowingly but not purposely, recklessly, and negligently but not recklessly. And you're right that in the third level is willful ignorance, which also entails recklessness, but it's more serious than recklessness because it's more serious than just recklessness because it involves this intention to not know. Yeah. So yeah, there's a.
We have a finger.
Related to this, I was wondering whether willful ignorance necessarily exclude knowledge about the relevant proposition.
Okay.
Because I was wondering, under which I believe is your conception
Yes.
of knowledge, if it's possible that the agent
Yes.
already knows the
Yes.
relevant proposition,
Yes.
but they are only putting themselves in the position not to know that they know. And it's
I
like
see.
something else. So you can treat willful ignorance as knowing.
But not knowing that you know.
Yeah. The only thing that is happening is the subject, at least in some cases, but particularly the cases that you are using, they already know the relevant proposition, but they are putting themselves in position not to know that they know, or something like this. So, and knowingly culpability is about awareness. It's not about knowledge. In your conception of knowledge, and I don't know if it's mine, but I think that it's possible to see that.
Yeah, that's a good point. So, don't I know that my friend is selling me a stolen laptop? So I agree that in many cases of willful ignorance, maybe there is knowledge. There can be knowledge.
You're avoiding the second order.
Yeah. So there's a question there whether all cases are like that, though. I mean, perhaps I have a strong suspicion, or suppose I, based on statistical evidence, I think that I'm getting sold a laptop that is stolen because the person fits the statistical profile. So in that case, perhaps you don't know. But nonetheless, you have a very high suspicion, a very high statistical evidence. So there would be a case where you can still be charged with willful ignorance in that case. So you're right that there's a question about whether all cases of willful ignorance are cases where there is real ignorance. But I think what is true is that there are cases of willful ignorance where there is genuine ignorance, and perhaps some cases the relevant ignorance is second order ignorance. Yeah, I think that's the right point.
Thank you, Jose Juan Moreson.
Thank you for this very suggestive presentation. I have two questions. The first question is one referring to the problems of translation between the criminal common law tradition and the continental tradition, because I'm not sure about that. I'm not sure. My impression is, according to the concept of the penal, of the model penal code, I don't know, purposively is something like direct dolus directus, say, the other, now the perhaps dolus of necessary consequences, reglas is like dolus eventualis, I think so, and negligence is imprudentia. But the problem in our tradition, in the continental tradition, is that the great difference and the great culpability, the great difference of culpability is between dolus and imprudentia. And a lot of cases of regulars are qualified as dolus eventualis here and punish with the same punishment with the case of purpose.
Oh, wow.
And that's, I don't know if you think that this classification represents even different grades of culpability, and it's important because in your presentation it seems to me that recklessly is more similar to negligently than to than the others. And in our tradition, dolus eventualis, the traditional example of dolus eventualis in the handbooks was the so-called case of Russian beggars. Russian beggars mutilate their children in order to get more money with the children. But in some cases, children died with this mutilation. But they clearly don't want that they didn't want that the children died with this process. And in this sense, what's the situation in this case?
Right. Yeah.
And the second question is more philosophical and related to that. It's but this qualification this qualification does not depend on the description of actions.
Yes.
Because one action can be purposive.
Yes.
Described in a way, and non-purposive described in another way. For instance, one terrorist group put a bomb in order to kill the passengers in a car. Describe that they kill the passengers in the car is purposive.
Yes.
But perhaps they want to kill the prime minister, and the prime minister this day is not in the car, and is in the car, I don't know, the daughter of the prime minister, and they do not want to kill the daughter. Moreover, if they know, if they knew that the daughter is in the car, they couldn't put the bomb in the car.
Yes.
But in the sense, describe that killing the daughter of the prime minister is not purposefully.
Yes.
And what's the
so it's very important.
What's the solution of this problem of description?
Yeah, so it's very important that we keep the description fixed, and it's true that different description, the same act may be purposive in some description and not others. And it's interesting because that will have different culpability verdict, but it's something that seems right. So in a way, like the subject that you described is a case where they did purposefully kill somebody. That's enough to be committed murder, even though they didn't purposely kill that particular person. And so there is at least one description which is true, and that's probably sufficient for committing them a murder. Yeah. So you're definitely right. We have to relativize to the description, and if the description is already murder, qualifies as a kind of a murder, then if it's done purposely, then All right. The other question, so it's very interesting what you said about different tradition, thinking about recklessness as more or less culpable. That's very interesting. So, in fact, there is a nice paper by Shona Sharifin, who is a legal philosopher at UCLA. She actually thinks that the U.S. Model Penal Code is too lenient on negligence. And she argues extensively that negligence is as bad as it gets. In fact, it's as bad as purposely crimes. So she's a Kantian though. So you can things get tricky there. I mean, So that's very interesting. Really. In a way, this project wasn't so much about buying this taxonomy as it is. I'm interested in trying to understand this different concept, but more like find evidence that look, the ignorance objection is not sufficient to dispel, rule out the knowledge-based account of culpability. At least once you have a more kind of fine-grained notion of culpability, and it may be that recklessness it should be more culpable than it's actually classified as. What is important is that even that level of culpability, whatever it is that you attach to it, can be understood by invoking knowledge, because it's a case where one shouldn't know. But you're right that really only focus on the U.S. Penal Code that encodes very strong substantive assumptions about culpability, and so it's interesting to see if something like this can be done for kind of other kind of traditions. Yeah, thank you.
Thank you.
In order to reach the lunch at time, I'm taking the words by two. So Luca and Dario.
Thank you very much for the presentation. Really interesting. A lot of topics, but due to time reason, I will only stay a bit on the puzzle of willful ignorance.
Yes.
You quoted the example of Spare. I was thinking about some interesting pages by Primo Levi when he reflects on what he calls the gray zone of the different involvement and responsibility, and it's difficult to judge both legally and morally this kind of different involvement. For example, he quotes the example of a worker, not a prisoner, on a genital laboratory in a camp. Who just told after the war that I didn't know. I do something, I didn't do anything to any person, I just didn't want to know. And Levi says it's very difficult to judge this case because he had a lot to risk if he chose to know. But in the same time, we cannot say he's innocent, he's totally innocent. So does this kind of example put the problem in our category? Does we can change the notion of willful ignorance, or do you think that it's the same case with Spare? And also, Levi quotes some cases of prisoners that were involved in some process and they choose not to know what their action was. They say it's another case. So, are these willful ignorance the same, or?
It sounds like a case.
We are taking another word, and then you answer both of them.
Yes,
sorry.
I have to remember them. Okay.
Dario.
Should I ask? Okay. No. So I really like the talk, and I think that there is something important to be said about this distinction between recklessness and willful ignorance. So I was thinking that the kind of account of willful ignorance that you put forth helps to distinguish between cases of culpable willful ignorance and cases of non-culpable willful ignorance. So my intuitions of culpability, of kind of negative evaluations, kick in only with the second bit of the account, like the intention not to know to avoid either the moral consequences or the legal consequences, because there might be some cases of intention not to know that are perfectly okay. So for instance, I might be sort of justified in being willfully ignorant about whatever is the latest conspiracy theory that has been put forth in this kind of circles, and then someone comes up to me and they tell me, do you want to know what is the most recent crazy thing that they said, and I'm going to say no, I don't want to know. And I'm willfully ignorant, and that seems to be good. But you know, in this case that you described, there is this kind of impression not to know, coupled with you know, some aim or some goal. And I think that's a nice feature of the account because it teases.
Oh, that's helpful. Thank you, Dario. I appreciate that. So I like when people help me out. Yes, great.
Quotable versus non-quotable.
Yes. Yeah, thank you. That's very helpful. Yeah, I should use that. Thank you. Good. And it was here. Yeah. I mean, prima facie seemed to me that it was the cases you were describing by Primo Levi were cases of willful ignorance. Although.
But he's not in the same position of Spur, the worker, because it's far less powerful.
Yes.
It's someone who has a lot of risk, which, whereas Spur maybe would do something without risking immediately his life.
So then the view would be that culpability doesn't just supervene on whether it's willful ignorance, but also on the position that you are within the crime, the wrongdoing. So the extent of which the person, Primo Levi's person, is actually doing wrongdoing is unclear too, right? Because it's contributing to the mission, but it's not as if is the main contributor or is the one that planned it all. So definitely, let's take the point.
Thank you.
Thank you,
Professor. And then Henry.
Sorry, I thought you were right. Thank you very much. I understand that under the model code, willful blindness is not explicitly mentioned.
Willful
blindness?
Yes.
Willful ignorance, sorry.
Well, so that passage of the U.S. model code.
And you said that, if a person is willfully ignorant, the law would treat the person as if.
Yes.
So willful ignorance actually belongs to the second level of culpability. The person is treated as if the person knew. So you don't find this sort of legal fiction for the other mental states. It's just peculiar to willful ignorance. So I'm very curious why does this mental state, why does this legal fiction? And the other answer to that, actually, when a person is willfully ignorant, the person knows. But that's very possible. But it seems to me that when a person is willfully ignorant, he has a high level of suspicion. However high, it is not knowledge. So my question is, why did the law create this legal fiction? And you don't find it for the other mental states. Recklessness is not legal fiction for something else.
Yes. Legal fiction.
All legal is fiction.
But I mean, it's true. I mean, but the idea, we are in the sort of culpability that willful ignorance is supposed to capture is that, it is as serious as the knowingly culpability because it was so easy for you to know. You deliberated not to. And so it makes sense that they use a counterfactual if you didn't come to know because you intended not to know. It makes sense that you use a counterfactual in assessing the degree of culpability that you should be charged with. So I wouldn't say it's legal fiction. It's just for the purpose of charging you with the conviction, they are just treating it as if you knew. And given the sort of cases they have in mind, it seems rather fitting because there are cases where one is very close to knowing, and so and they could have known. They had the opportunity to know. They could know, and they just avoided doing it for avoiding prosecution. So I wouldn't call it fiction, but yeah. So I think the counterfactual is fitting because, and I also don't think that all the cases of willful ignorance are cases where you actually know. Many cases are cases which you don't know.
But the level of culpability is the second one. Right?
Yes, absolutely, yeah.
Thank you. If Henry is very sharp, I can allow also Jaime to ask.
Sure. It's about it's a curiosity about Gracia cases.
Oh, yeah,
How
see.
it feel in your scheme,
Yeah.
because in some sense the agent knows that something is wrong,
Yeah.
that he has to do it,
Yeah.
but he forgets about it because he's dealing with something else. For example, the example that you put of the negligent doctor, maybe he knows about the procedure that he has to do,
Yeah.
but he forgets it because he's seeing the sky resort or something like that. In some sense, you can say that he doesn't know that what he's doing because he forget about it. He knows that he should do it, but
Yeah.
he's not doing it.
So did you start talking about acrasia? Yeah.
Yeah.
Oh wow, you think that's a case of acrasia? I would have thought that that's not a case of acrasia.
You could put another cases how it deals with how your scheme with crazy cases is more.
Yeah, so I mean, I actually think acrasia cases of intentional action that are done against one's best judgment. So acrasia counts as bad as culpability 1 and culpability 2 if they're committing a crime. Yeah. So because those are the level of which intentionality matters. So if that's how you're thinking about acrasia, and that's a popular way of thinking about acrasia, cases of intentional action that are done against one's best judgment. So they will be covered by culpability 1 and culpability 2. Yeah.
Very short.
Yeah.
So my question is there any difference between that notion of culpability and the notion of blameworthiness, or are coextensional terms?
Yes.
Because maybe blameworthiness can grasp any of the if the make a relationship between culpability and blameworthiness, maybe can capture that problems of willful ignorance or nothing.
Yeah. So I was thinking that legal culpability is just one subset. There's more things that are very worth in that we're culpable legally for. But I was thinking that in the moral domain, blameworthiness and culpability are pretty much coextensional. So culpability is something that attaches just like moral worthiness goes with praiseworthiness in the moral domain. So similarly, blameworthiness goes with wrongness of action that come with certain mental states of the agent, like motivational states and knowledge states of the agent. So I wasn't drawing a distinction there between blameworthiness and culpability. I'm not quite sure whether there are cases where you would say that they are blameworthy but they're not culpable, or vice versa. I mean, I don't. In the moral sense, in the legal sense, yes, but not in the moral sense. So, given that this was in the service of a kind of more general moral understanding of culpability, then I don't think that will help with distinguishing between willful ignorance and recklessness. But I'm happy to hear if you have some clear example where blameworthiness and culpability come apart. I'm not sure. Yeah.
Thank you. Before.